A question that I often hear from board of directors is whether their association can impose a lien to collect unpaid assessments from owners. As board of directors know, running an association is a lot like running a business in at least one respect. Revenues have to meet or exceed expenses, but that can be tricky if you've got homeowners that aren't paying their dues. What can a homeowners association do to prevent free riders and make sure everybody pays their fair share? Hi, I'm attorney James Perero, and one of my practice area focuses is homeowner association law with the law firm of Widders Gibson Jones Feingold. One tool that many homeowner associations have in their toolkit is the power to enforce a lien for non-payment of assessments. A lien is a powerful tool. With a lien properly in place, a homeowner association can begin the process of forcing the sale of an owner's residence to collect a debt. Or, the association can record the lien and then wait. If an owner wants to refinance their residence, any lender who's giving them money for the refinance is going to require that their security, that their lien on the property is in first position, which means they're going to require that owner to clear the lien, which means the association gets paid. Or, if the owner's selling the property to a third party, the same thing's going to happen. That third party is not going to want to take that property subject to the lien and will require the owner to pay the debt. However, an association can only use a lien to collect debts under specific circumstances. The first is that the CC&R'S have to authorize the association to use a lien to collect the debt at issue. Second, the Civil Code must also authorize the association to impose the lien for the debt that's at issue. The first type of debt the Civil Code allows an association to collect with a lien is for unpaid or delinquent special or regular assessments. The second type of debt, the Civil Code also authorizes the homeowner association to impose a lien in a situation where the owner or the owner's guest has caused damage to the common area. In that case, the association typically repairs the damage and then imposes a reimbursement assessment against the owner. If the owner doesn't pay the reimbursement assessment, the association can impose a lien to collect that assessment if the CC&R'S authorize it to do so, and the Civil Code has a provision right on point. Third, the association must carefully follow its CC&R'S and the Civil Code, or risk having its lien invalidated at a later date. There's nothing worse than an association spending months trying to collect a debt after they've recorded a lien, only to find out that there's an error in the process that threatens to invalidate the lien. That would prevent the association from using the lien to collect its debt, and can also expose the association to liability. If you have questions about whether your association can impose a lien to collect an unpaid debt, call us at the Widders Gibson Jones Feingold Law Firm at 805-644-7188. Thanks for watching.